05-16165. Today is Wednesday, August 13th, and the time is 9:28 a.m. I am Judge Kletter, and with me is Administrative Law Judge Teresa Stanley and Hearing Officer Erica Parker. While I am lead ALJ in conducting this hearing, all panel members are co-equal decision makers. Ms. Alonso is reporting this hearing verbatim. As I mentioned earlier, to ensure we have an accurate record, we ask that everyone speak one at a time and does not speak over each other. Please speak clearly and loudly. And the hearing transcript and video recording are part of the public record. I'd like for the parties to please each identify yourself by stating your name for the record, beginning with appellant.
Marquez Lister.
Thank you. And for Franchise Tax Board.
John Lee.
Jackie Zumaida.
Thank you so much. And our hearing today is, the issue that we're hearing is whether the statute of limitations bars appellant's claim for refund for the 2018 tax year. With respect to the evidentiary record, FTB provided exhibits A through L. Appellant did not object to the admissibility of these exhibits. Therefore, those exhibits are entered into the record. And appellant has provided exhibit 1. FTB did not object to the admissibility of this exhibit, and therefore this exhibit is entered into the record. As a reminder, we have 10 minutes for appellant's presentation, 10 minutes for Franchise Tax Board's presentation, and then appellant, you'll have 5 minutes for a closing statement and rebuttal, anything you'd like to respond. Mr. Lister, are you ready to begin your presentation?
Yes.
Please go ahead and begin.
Okay, my problem is the state called me, said we need some...
Mr. Lister, would you mind, is your microphone on? Or?
Yeah, it's on. Can you hear me? Okay.
Better, thank you.
The state called me, asked me for information, bank accounts and all that, gave them all the information they needed. The lady told me I had till the 15th before any actions would be taken against me to file. I said, okay. I filed on the June 15th of 22. June 15th of 22 is when she said it had to be in and no action be taken against me. I filed my returns for 15/22. After that, some time went on, and they still garnished my wages plus an extra $5,200. That's why I'm here today. I feel I was treated unfairly. If you're gonna give me an extension to file, you're gonna call me and ask me for information to give you. I gave you all my information. I didn't run from anybody, and on the end, you're gonna say that, oh, okay, no, we're not going to grant you that. All this money, we'll take this and go on about your way. And that's how I feel the state is treating me. I also had a certified mail receipt to make sure that they received it in time enough so that I wouldn't have any actions taken against me. And then also, no, that's it. They can go ahead and proceed.
Mr. Lister, as we discussed during the pre-hearing conference, to the extent that you're providing testimony about what FTB said to you or your personal knowledge, I can swear you in so that we consider that testimony as evidence.
That's fine.
Do you swear or affirm that the statements that you just provided are, please raise your right hand. Do you solemnly swear or affirm that the testimony that you've provided is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. So now I'm going to turn it over to Franchise Tax Board. You'll have 10 minutes for your presentation. Mr. Lee, are you ready to begin?
Yes, thank you.
Please go ahead.
Good morning. My name is John Lee, and I, along with Jackie Zumaida, represent Respondent Franchise Tax Board. The issue in this appeal is whether appellant has established that he filed a timely claim for refund for the 2018 tax year prior to the expiration of the statute of limitations. The evidence will show that he did not as to the barred overpayment. Under the applicable section of the Revenue and Taxation Code, The general statute of limitations provides that the last day to file a claim for refund is the later of 4 years from the date the return was filed, if it was filed within the extended due date, which does not apply here. 4 years from the due date of the return, without regard to extensions, or 1 year from the date of overpayment. Appellant late filed his 2018 tax return on January 29, 2024, after the 4-year statute of limitations expired on April 15, 2023. Furthermore, the latest payment on appellant's 2018 tax year account was made on June 28, 2022. Therefore, the 1-year statute of limitations is also unavailable to allow a refund of appellant's remaining overpayment for the 2018 tax year. Appellant contends he filed his claim for refund in the form of his 2018 tax return on April 15, 2022. If a taxpayer claims a return was timely filed by mail, the taxpayer must provide compelling proof, such as a certified mail receipt. In support of his claim, appellant has provided copies of certified mail receipts for envelopes sent both to FTB and the IRS for April 15, 2022, in which he contends contained his 2018 tax year returns. However, FTB has no record of receiving appellant's 2018 tax return on that date, and a certified mail receipt does not prove the contents of the envelope. Extrinsic evidence, such as FTB's official records, may be considered to show whether something was timely mailed. Appellant has not provided any evidence to suggest that his 2018 California tax return was placed in the same envelope as the one sent by certified mail on April 15, 2022. Additionally, a review of appellant's 2017 tax year account indicates that he filed his 2017 California tax return on April 15, 2022, which strongly suggests that the provided certified mail receipt corresponds with the filing of his 2017 tax return. Lastly, in a phone call with FTB on July 7, 2023, over 14 months after the alleged filing of his 2018 tax year return, appellant acknowledged that he still needed to file his 2018 California tax return. Moreover, the IRS has no record of a return filed by appellant on or near April 15, 2022 for the 2018 tax year, but does show receipt of appellant's 2017 federal tax year return that similarly coincides with the certified mail receipt date provided. As such, based on compelling extrinsic evidence, January 29, 2024 is the date of actual receipt of appellant's 2018 California tax return, and the certified mail receipt is insufficient to establish an earlier filing date. The Office of Tax Appeals, in its presidential opinion in the appeal of Benembi Partners, held that the language of the statute of limitations is explicit and must be strictly construed. The United States Supreme Court in United States v. Dahlm explained that this is true even when it is later shown that the tax was not owed in the first place. Appellant has not provided sufficient evidence that will allow FTB by law to grant his claim for refund. Therefore, FTB respectfully requests that the Office of Tax Appeals sustain FTB's claim for refund denial for the 2018 tax year. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Lee. I'm actually going to ask Mr. Lister, is there anything that you would like to say in response, a final statement, or anything else that you've prepared or would like to say? And then I'll turn it over to the panel members for any questions.
Yes, the Franchise Tax Board sent me something that's saying that I had a total overpayment for the tax year of 2018. So it shows that they did get something.
Can you let me know what is on the piece of paper that you have in your hand, or what is it titled?
Statute of limitations. We recently processed your income tax return or claim. And they're saying that they didn't get it for 2018, and the tax year clearly states on the top right-hand corner it says 2018.
So that is Exhibit 1 in our record. This is the statute of limitations notice.
Yes, and and also, had they not had me the certified mail receipt does show proof that I sent this in when they asked me to, after they had called. On top of that, I wouldn't have, if I had not sent it in, from the garnishment, I have 1 year, right? This is before the 1 year anyway. So had they had not called me and had me file and send those documents in, I would have waited, and then I would have been able to file after the time that they garnished me would have put me well within the 1 year. So I'm ahead of them by an extra 3 months before, or however many months before the 1 year statute of limitations to allow me to file for that year. If that makes any sense to you.
Yes, noted. Was there anything else that you wanted to add, or I can turn it over?
No.
I'm going to ask Judge Stanley. Did you have any questions for either of the parties?
Just a clarifying question for Mr. Lister. The Franchise Tax Board says that certified mail receipt appears to be for your 2017 tax return instead of your 2018 tax
No,
return.
I
Okay,
had- oh, sorry.
Wait till I
Go ahead.
finish. I'm just wondering if you can see or show me anywhere on that receipt where it provides which tax year you sent in, which tax
It
return.
was they made me do 17 and 18, and I have two separate receipts. One was for 17 and one was for 18. Certified mail receipts. I'm sorry.
So you're showing us two receipts. Did you submit both of those?
Yes, both of those are on the same certified mail document. They're on that page.
It looks like one of the certified mail receipts is addressed to Cincinnati, Ohio, and then the other one is to Sacramento, California.
Okay.
What is that?
Okay, I can just clarify. I
Maybe.
can see that it's written IRS on the first receipt.
Mm-hmm.
Thank you. I don't have any more questions.
I'm going to ask Hearing Officer Parker, do you have any questions for either of the parties?
Yes.
One other thing. This is 2018.
Noted.
Okay.
I do have a question for Mr. Lister.
Yes.
So the FTB is acknowledging that they did receive the 2018 tax return and that it was filed on January 29th, 2024, which is the tax return that you filed. Is that correct?
January 29th? No, I got.
That would be Exhibit F in the record.
Can I see your copy?
So my question is, so this one was filed on January 29th. And my question would be, what prompted you to file the 2018 return in 2024?
The phone call. You guys called me.
The Franchise Tax Board called you?
They called me. That's where these dates came from.
Do you know what month they called you or when they called you?
Maybe. So you guys don't have no record of them, you guys calling me?
If Franchise Tax Board can give you the exhibits, there's an Exhibit K that has the Franchise Tax Board provided the call logs.
So the call log there that they shared with you was dated July 7th, 2023. And so my question is, if you
July. What
were-
about? no April, no May, or is this for different calls?
Yes, those would have been other ones. The 7/7 is the one that they provide the detail for the conversation, where
July 7th.
It's page 2 of Exhibit K.
Page 2. It doesn't say it on this page. Exhibit K, page 2.
Oh, I'm sorry. It starts at the very bottom of page 1. It says comment detail,
Oh,
date and
July
time.
7th.
And then continues on to page
Is that the initial call? No.
this is the July 7th. But I do see now that it does say there that you were advised that you needed to file the tax year 2018 through 2022. And that was on July 7th. So is that the reason that you submitted the return,
Yes.
the January in 2024?
There were two separate instances. No, because this is after the call that I got. The call was before July.
Okay. So you filed this tax return in January 2024 after a conversation with FTB?
After the
Is that why
conversation
you
with
filed-
FTB, they told me to file. Oh, I'm sorry. I forgot just now. Gotcha. Gotcha.
I apologize. So the call, you received a call, and that prompted the filing of the 2018 return in 2024?
That was 2022.
Okay. I think that answers my question.
Okay, so now that we've gone through the questions from the judges, I actually don't have any questions myself. So this concludes the hearing, and the panel will meet and decide the case based on the documents and the testimony that was presented. We will issue our written decision no later than 100 days from today. The case is submitted, and the record is now closed. This concludes this case, and we're going to go off the record. And I just want to also say that the next hearing will